Welcome back, everyone, to another deep dive. Today, we are going to get into something pretty heavy, and, it's a process that can be really confusing and complicated, too.
Yeah,
We're going to be talking about finalizing a divorce or a legal separation here in California, specifically when there are kids involved,
right.
minor children.
Yeah, absolutely. It could be really overwhelming,
Oh, yeah.
especially when you're looking at just a mountain of paperwork and trying to figure out where to even begin.
Where to even begin,
So
yeah.
we're going to try and bring some clarity to this process.
Okay.
We're using this Judgment Checklist Dissolution Legal Separation Form from the Judicial Council of California. It's also known as FL 182.
Gotcha.
And think of this as your roadmap.
Okay.
It lays out all the documents that you'll need depending on your specific situation.
Right. And just to be super clear, we are not giving legal advice here.
No, not at all.
We're just taking a look at this form and trying to make sense of it all together.
Eggs.
So we're going to walk through different scenarios, like what happens if the other party just doesn't respond at all? Or, you know what, if you've actually reached some kind of agreement.
Right.
The goal is that by the end of this deep dive, you'll have a way better understanding of what's required in your particular situation, and hopefully you'll feel a little bit more in control.
Yes, definitely.
Okay, so let's jump right in.
Okay.
So let's say one party just completely ghosts the whole thing.
Right.
No response to the divorce or separation filing at all.
Yeah.
And there's no agreement in place.
No written agreement. No.
Okay, what happens then?
So the checklist refers to this as default with no agreement.
Okay,
And in this case, the person who filed initially, the petitioner,
right.
has to file a bunch of different documents with the court.
Okay.
The very first thing is the proof of service of summons, that's Form AFL 115, or some other official proof that the other party, the respondent, was properly notified about the case.
Right, you can't just assume that they know what's going on.
Exactly. You have to make absolutely sure that they're aware.
Right, okay.
And then after that, the petitioner has to file a request to enter default that's Form FL 165.
Okay.
And there's a little detail here that's really important.
Oh, really? What is it?
So when you file this request, you also have to include 2 stamped envelopes.
Okay.
One addressed to the respondent, and the other one needs to have the court clerk's address on it as the return address.
Okay, so even though they're not responding, the court still wants to be able to communicate.
Exactly. It's all about keeping those lines of communication open just in case.
Right, that makes sense. What's next on the list?
So after you've established that the respondent was served and you've requested the default, the petitioner needs to file a declaration regarding service of declaration of disclosure,
Okay.
and that's Form FL 141.
Oh, right.
And basically, this just confirms to the court that the petitioner has given their financial information to the other party, even if that party hasn't really participated.
So it's about transparency.
Yeah, exactly.
Even when the other side isn't engaging.
Right?
Okay, and after that,
You'll need to file the declaration for default or uncontested dissolution or legal separation.
what form is that?
That's Form FL 170.
FL 170.
And this declaration just lays out the facts of the case to support the judgment that the petitioner wants.
Okay, so you're really building up the case piece by piece.
Exactly.
And then I assume comes the judgment itself.
Yes, you got it. The judgment.
Form FL 180.
FL 180, that's the one. And here's something you might not expect. The checklist says you need 5 copies of this form,
5 copies. Wow, why so many?
probably to make sure everyone has a copy for their records, the court, the parties, everyone involved.
Right, that makes sense. Okay, so 5 copies of the judgment and
And you also have to file a notice of entry of judgment,
right.
which is Form FL 190.
Uh-huh.
This just formally notifies both sides that the judgment has been entered by the court.
Okay, so it makes it official.
Exactly.
And then are we done with the envelopes yet?
Not quite.
Okay.
You also need 2 more stamped envelopes.
Right.
Make sure they're big enough and have enough postage.
Okay.
One goes to the petitioner and the other one goes to the respondent.
Right, so the court can mails back the signed judgment and the notice of entry.
Exactly.
Okay, so even though one party's MIA, the court's making sure they get all the important documents.
Yeah, absolutely.
Okay, so now let's talk about the kids.
Right.
Since this whole deep dive is focused on cases with minor children,
Yeah.
what kind of paperwork is absolutely crucial in this default scenario?
So there are a few key forms that protect the kids' well-being and their legal rights.
Okay.
The first one is the Declaration under Uniform Child Custody Jurisdiction and Enforcement Act.
Wow, that's a mouthful.
It is, we usually just call it the UCCJEA form.
Okay, much easier.
It's Form FL 105.
All right.
And this form helps the court figure out which state has the authority to make decisions about the kids.
Right, so like if one parent moved out of state with the kids.
Exactly. This form helps clarify where those custody decisions are to be made.
Gotcha.
And it's super important to file a new UCCGEA form if any of the information on a previous one has changed.
Okay, so always keep it up to date.
Always.
Okay, what else is there for the kid?
So the court needs financial info from the petitioner to figure out child support.
Makes sense.
So they'll need to file their income and expense declaration, that's Form FL-150,
Okay.
or a simplified financial statement, which is Form FL-155.
All right.
Unless they've already filed a recent one that hasn't changed.
Right.
And it's a good idea to include a computer printout of the guideline child support calculation.
Okay, is that required?
It's listed as optional,
Okay.
but it's definitely good practice.
Yeah, it shows how the support amount was determined.
Exactly. Transparency is key.
Right. And what about, laying out each parent's rights and responsibilities when it comes to child support?
Yeah, you're talking about the Notice of Rights and Responsibilities and Information Sheet on changing a child support order.
Wow, that is quite a title.
It is Form FL-192 for short.
FL-192, got it.
And this one's required.
Okay.
The checklist says the petitioner can attach it with their paperwork, or the court can do it.
Okay, so either way it needs to be there.
Right, and then you need a formal child support order.
Okay.
This could be on Form FL-350,
Uh-huh.
which is used to establish or modify child support,
Got it.
or it could be on Form FL-342, which is the child support information and order attachment.
Okay.
Or sometimes the party might have a written agreement about child support that meets certain legal requirements.
Okay, so there are options.
Yeah, but no matter what, it has to be attached to the main judgment document.
So several ways to make it official.
Right, and then to make sure the support payments are actually made.
Right, because that's often an issue.
There's another important form.
Okay, what is it?
It's called Income Withholding for Support.
Okay.
It's Form FL-195.
FL-195. All right.
And this one's mandatory whenever child support is ordered.
Gotcha.
Basically, it lets the support payments be taken directly from the payer's wages or other income.
So it takes out the guesswork.
Exactly.
And makes it a lot harder to avoid paying.
Exactly.
Okay, and lastly, for the kids, we need to talk about custody and visitation.
You got it.
How does that usually work?
So this is usually done with the Child Custody and Visitation Parenting Time Order Attachment,
Okay.
Form FL-341.
All right.
Or they can use another written order that includes all the necessary information,
Okay.
but no matter what, it has to be attached to the judgment.
Okay.
So that lays out the specifics of the custody and visitation arrangements.
So even when one side is totally silent, there's still a lot of paperwork involved?
Yeah, there is.
Especially when kids are in the picture.
Yeah, the court really wants to protect the kids and make sure their rights are covered.
It definitely seems that way.
It does.
Okay, so let's switch gears a bit.
Okay.
Let's talk about a situation where the respondent still doesn't formally respond to the divorce filing,
Right.
but there is a written agreement.
Okay, a default with agreement.
Default with agreement, that's what the checklist calls it.
Yeah.
Okay, so they haven't filed an official response, but they have signed a written agreement.
Exactly.
So how does that change things?
Well, some things might seem simpler because there's an agreement,
Okay,
but there are also some very specific requirements.
like what?
So the written agreement itself becomes super important.
Okay,
The checklist really emphasizes that the respondent's signature on this agreement has to be notarized,
okay,
and the whole agreement needs to be attached to the judgment.
gotcha.
This notarization basically proves that the respondent agreed to the terms even though they didn't go through the formal court process.
Right, it makes their signature official.
Exactly.
Okay, and what about the financial disclosure stuff?
So there are some differences here, too.
Okay.
The petitioner still needs to file both a preliminary and a final declaration regarding service of declaration of disclosure.
Okay, so that's still the FL-141.
Yep, both of them are FL-141,
Got it.
unless they qualify for a waiver.
Okay.
This just makes sure that the initial exchange of financial information happened. But because there's an agreement, the parties can file a stipulation and waiver of final declaration of disclosure.
Okay, and what form is that?
That's Form FL-144.
FL-144, all right.
Or they can include a separate waiver that follows the rules in the California Family Code.
Got it.
Basically, these waivers mean both parties agree they don't need that final detailed financial disclosure because they already settled everything.
Okay, so the agreement can streamline things a bit.
Yeah, it can.
But they still need to document that initial sharing of financial info?
Exactly, unless they get that waiver.
Okay, what about the child-related documents? Do we still need all those?
Yeah, most of them are still necessary.
Okay.
You'll still need the declaration under UCCGEA Form FL-105.
Right,
And remember, it needs to be updated if anything's changed.
of course.
And the petitioner still needs to provide their income and expense declaration or the financial statement if they haven't filed a current one already.
Right, and that's the FL-150 and FL-155.
Yep, those are the ones.
Okay.
And it's still recommended to include that computer printout of the guideline child support calculation.
Okay.
just for clarity's sake.
So those are all pretty much the same.
Yeah.
What about the actual orders for child support and custody?
So this is where that written agreement comes in.
Okay.
A lot of times the agreement will spell out all the details about child support and custody,
Okay.
and they might actually use the official court forms like the FL-350 or FL-342 for child support, or FL-341 for custody.
Right.
Or it could be a separate document that they drafted themselves.
Okay.
But if it's a separate document, it still has to include all the required information from the California Family Code.
Okay, so there are rules even for custom agreements.
Right, and all these details from the agreement will then be included in the final judgment.
Gotcha.
And of course, if there's child support, the income withholding for a support form is still required.
Right, the FL-195.
That's the one.
Okay, so the agreement doesn't replace the need for formal orders.
No.
But it provides the substance for those orders.
Exactly.
And the notarization of the respondent's signature is a key difference in this scenario.
Yes, it really highlights how much weight the court gives to that agreement, even without a formal response.
Okay, so we've covered the default scenarios.
We have.
Let's move on to the final one.
Okay.
The uncontested case.
Right.
So in this case, both parties are actively participating.
Yeah.
The respondent has filed a response or appeared in court, and they've reached a written agreement.
They have.
Sounds like the most cooperative way to do things.
It usually is.
So what's different here?
Well, because both sides are involved and they agree on everything.
Right.
Some of the requirements change a bit.
Like what?
For example, if this is the respondent's first time officially appearing in the case,
Okay.
they usually have to pay a filing fee.
That makes sense.
Unless they get a fee waiver or are on active military duty.
Okay. Standard court procedures.
Right.
What about those declarations regarding service of declaration of disclosure?
So in this case, both the petitioner and the respondent have to file their final declaration.
Okay.
Using that FL-141 form. This confirms that they both exchanged their full financial information.
Okay.
But just like in the default with agreement, they could choose to file a stipulation and waiver of final declaration of disclosure.
Right, Form FL-144.
That's the one.
Or they can use a separate waiver that follows the California Family Code.
Right.
So basically, they're saying they don't need that final detailed disclosure because they're already on the same page.
Exactly.
And the checklist also mentions those preliminary declarations for both parties.
Yes, it does.
To show that initial exchange of basic info happened.
Right.
Okay, so even though everyone agrees, the court still wants to see that financial transparency happened.
Or that both sides consciously waived it.
Right, okay. Are there any other forms that come up in an uncontested case?
Sometimes you'll see the appearance stipulations and waivers form.
Okay.
That's FL-130.
FL-130.
Okay. It's useful for documenting the respondent's appearance and any agreements or waivers.
Got it.
And of course, that comprehensive written agreement is central to this whole thing.
Right.
And it has to be attached to the final judgment.
Okay, so the agreement's still really important.
Yeah.
And what about the forms for the kids?
Those are still essential.
Okay.
You still need the UCCJEA form FL-105. And remember to update it if anything's changed.
Of course.
It's still good practice to include that computer printout of the child support calculation.
Okay.
Even though it's optional.
And the child support order itself?
Right, whether it's on form FL-350, FL-342, or detailed in the agreement,
okay,
it'll be part of the final judgment.
And the income withholding form if child support's ordered?
Yep, that's still necessary.
And custody and visitation arrangements?
Yeah, those will be spelled out in the child custody and visitation order attachment or within the agreement.
Right.
And that's attached to the judgment as well. And finally, there's the notice of rights and responsibilities and information sheet on changing a child support order.
That's the FL-192?
Yep.
And either party can attach it or the court can?
That's right.
So even in the most agreeable situation, the paperwork for the kids is still a huge priority.
It really is. The court always wants to make sure the kids are protected.
Definitely makes sense.
Yeah.
So we've covered 3 different scenarios.
3 very different paths.
But there are some common threads.
There are.
Especially when it comes to the kids.
Right.
What are those key similarities?
So whether it's a default or uncontested case, the UCCJEA form FL-105 is always required.
Okay.
And it's got to be kept current.
Got it.
And any forms about child support, like the guideline calculation, the child support order itself, and the income withholding form, those are all essential.
Right.
And you always need forms for custody and visitation arrangements.
Of course.
And then the judgment form, FL-180.
5 copies of that one.
5 copies. And the notice of entry of judgment, FL-190. Along with those 2 stamped envelopes.
Right.
Those are all standard requirements.
Okay, so even though the level of agreement changes things.
Yeah.
There's a core set of documents that's always needed when she's involved.
Exactly. And it all comes down to protecting the children and making sure their needs are met.
Absolutely. Well, this deep dive has been really enlightening.
I agree.
I feel like I have a much better understanding of what goes into finalizing a divorce or separation with kids in California.
Me too.
And I hope our listeners feel the same way.
I hope so too.
Hopefully this has helped to demystify the process a bit and maybe even make it feel a little less daunting.
Yeah, knowing what's required can definitely make you feel more in control.
Definitely. So before we wrap up, I want to leave our listeners with something to think about.
Okay.
So we talked about these different ways to finalize a case, the default scenarios where one party's not responding,
Right.
and then the uncontested route where everyone's involved. I'm curious, what are some of the unseen, the emotional and practical realities of each of these for families, especially when kids are involved?
That's a really important question.
It is. I think it's easy to get lost in the paperwork,
Yeah,
but we can't forget about the human side of things.
absolutely.
So that's something I want our listeners to reflect on as they navigate this process.
I think that's a great takeaway.
Thanks so much for joining us for this deep dive, everyone.
Thanks for having me.
We'll see you next time.
See you then.